Hello, everyone. In the H4 EAD lawsuit case, we just had an intervenor brief submitted to the court by Immigration Voice and others. So as you can see, it was submitted about 5:15 evening, and we wrote the article on that. So here is the video summary of it, right? So firstly, the brief is actually represented by about four parties. One is the intervenor, who is actually Immigration Voice, and the three other agencies are Chamber of Commerce of United States, Information Technology Council, and National Association of Manufacturers. Right? The whole idea is these all of these three entities essentially employ about 12 million men and women. The organizations that they represent employ about this many amount of men and women, and they create an overall value of $2.25 trillion, and representing over 1 million plus businesses, right? So overall, the reason for all of them to be part of this is that it has a significant impact to their employers, or their employees of these organizations. So that's why all of them have supported this and submitted this brief as the intervenor, right? If you look at the primary argument points that is put together by this third party interveners, is basically, firstly, they actually try to highlight the value of H4 EAD, right? So what they look at is things like some really good stats on how it's making an impact to the US economy. So some of the key points are, it actually adds up to 7.5 to $15 billion GDP per year, yeah, which is actually a significant number. And the amount of taxes paid by them are about $1.9 billion annually to the federal government, and $513 million for the state and local governments. So this is a huge number of from any magnitude, right? If you look at them, so all of these will be lost if at all something happens to this. And again, the second one is about the decisions that are taken by these H4 EAD holders based on this regulation and how many families it will impact. So some numbers they've given are about 27,000 families have decided to have a child, 52,000 families have bought a home, some of them invested in higher education, and about 90% of them are females, which is actually will create a disproportionate effect on the women. Nowadays, it's actually an important factor, diversity, that every companies are encouraging. So I think this will have a big effect on all of them. So overall, these are some of the hardships that could be created if this rule were to be revoked, right? And the third one, they look at it, okay, this impacts American workers, but how far is it true? So what they say is two-thirds of the spouses, H4 spouses that are employed in this occupation, have unemployment rates of only 2% or less than 2%. And the study tells that this 2% is basically transition jobs, people who are looking for a new job, or they're moving from another job to a new job. So it's not really impacting per se. Yeah. And also the second fact they say is about about these the jobs that are currently displaced are actually offsetted by the jobs created because of the H4A holders create businesses. So they say that about 2% of the H4 spouses create businesses, which actually in turn hire Americans, and this will actually boost the overall economy. So nullifying that whatever has been displaced that is being claimed. So overall, I think this is some of the positive points that they raise. Now, in terms of the second aspect that Save Jobs USA raised is regarding the lawful exercise of their power, right? They abuse their power and they created this, right? That's what they claim. So what the first thing they say is, okay, if the court believes that something like that has to be done, you should send it back to the district court, because district court gave a standing, and your job is to just look at that, and if you believe that this is not done right, then you have to send it back, because this point was not discussed, and they clearly say that Save Jobs USA lacks standing in the lawsuit. That's the only judgment that was given there, right? Nothing more than that. So I mean, if at all the court believes that this is wrong, so they should send it back to the old court. And I mean, they also talk about that the currently H4EAD is being going through the role revocation process by DHS, so they also add that part. Now, some of the things that they raise is that they raise are like regarding the DHS authority. First one is the power to make the rule, under INA, right? So this was not controversial for many years, and this has been used for the last 25 years, and this should not change now. I mean, this is what Save Jobs USA is raising, that this is controversial, it cannot be done. But this has been there like this for the last 25 years, and it's the Attorney General has this authority to grant employment for aliens, and it shouldn't be raised now. It has never been a problem for 25 years. Yeah, that's the first point. The second one is, I mean, the interpretation of the, there is a section called 1324A, which is basically Attorney General authorizing non-citizens to work, right? So, and they, Save Jobs USA tells that this is just a definition, and does not authorize, understand, and this is actually wrong. That's what they say. So overall, uh, they're misunderstanding the point, and what even they raise another issue where they talk about say Jobs USA raises a Fifth Circuit court in Texas versus US regarding work authorization of undocumented immigrants. But in this case, these are all fully documented immigrants, fully documented people in the US, and they are actually set to become the permanent resident. So this actually does not really apply here. So the interpretation, everything is correct. So the Attorney General had the power to actually do all of these things. And the third one is adopted text of the interpretation of the rule was actually was enacted in and accepted by Congress, because Congress never really rejected such thing, right, of the interpretation. And Congress also amended this since it introduced, and never objected that executive branch claim of authority. This you can see that many of these actions have been carried in the past, and there are many agencies that have created many other laws. So basically the Congress is accepting it, and it's not really against whatever that the Congress is not approving this kind of things, right? So this power has been given by the Congress, and they never contested for this. And the third part is that this says, the Congress did not preclude essentially means prevent from happening or make it impossible, right? The H4 spouses, what it means is, hey, Congress never gave authorization to H4 spouses. Why are you giving it now, while they gave it for other spouses? So the point of argument is Congress actually gave authorization for many types of spouses, but they never mentioned anywhere that they do not intend to give that for H4 spouses. So having no comment doesn't mean they will not. Their intention was not to give. So this is not this is not really the intent of the Congress. So that's what they clarified. So overall, the conclusion says that the H4EAD is rule is lawful exercise of DHS authority. That's what the team concludes, and they put forth a request telling that this is going to have a significant impact to the businesses, and there are a lot of thousands of families that have already planned their life around this. This has been since 2015, so it's something that cannot be like done like this, right? Based on some of these things. And worst case, if at all something has to be done, this has to be sent to the previous court for further review. Yeah. So that's about it, folks. I mean, overall, it's a very positive, news for H4ED. So these are some valid points that are raised. So definitely, now the next steps are so now there are two steps are over. The appellee's brief is filed, the intervener's brief is filed. So we are expecting the appellant's brief, reply brief in April 29. So they have 20 days to actually respond to both of these, right? So next 20 days is just a waiting game. So just to clarify, all the H4EAD holders, do not be in any panic. You can actually file H4EADs. So this is a continuing litigation on one side. So you can continue to file your H4EADs. That's first part. So don't be taken by this. No, second part is on the OMB rule, right? On the OMB rule, it's still in pending state. So there is no update as of today, which is April 8th, right? So we are still waiting for that. So again, all of these changes are dynamic, and things are moving on. So don't be in panic mode. If you are eligible, just go ahead and apply for it. Yeah, that's about it, folks. Definitely, subscribe for updates. We keep adding more latest information and news on various aspects of this. Do subscribe for updates, and look forward to sharing more videos with you. Thank you. Bye.